Everyone knew him as one of hip-hop's most controversial artists. But when Kanye West stood up in federal court that day, he was about to reveal a secret he had kept hidden for over 15 years. Not just musical genius, but deep intellectual property law expertise, years of studying copyright and trademark protections, mastery of constitutional creative rights. Judge Ketanji Brown Jackson was dismissing him as just another rapper seeking attention, unaware that standing before her was someone who understood intellectual property law better than most entertainment attorneys. Kanye's first legal argument alone would completely transform Jackson's perception. "Your Honor, Judge Jackson," said Kanye, his voice carrying the same intensity that had made him a global icon, "may I speak to you about the Copyright Clause's relationship to artistic expression and the constitutional limits on intellectual property enforcement?" What happened that day in the New York federal courthouse would revolutionize both intellectual property law and our understanding of artistic constitutional rights. Before diving into this extraordinary legal confrontation, don't forget to like this video and subscribe to our channel for more stories of unexpected legal brilliance challenging established authority. Character introduction and background, 2 to 4 minutes. Jackson's world, progressive legal authority. Judge Ketanji Brown Jackson represented the intellectual progressive legal establishment. At 53, the first black woman Supreme Court justice had built her reputation on careful constitutional analysis and deep commitment to legal precedent. A Harvard Law graduate with extensive experience in federal appeals, Jackson embodied scholarly judicial excellence. Her judicial philosophy emphasized thorough legal analysis and protection of constitutional rights, but she maintained skepticism toward celebrity involvement in complex intellectual property litigation. Jackson particularly questioned whether entertainment personalities possessed the legal sophistication necessary for serious constitutional discourse. That day, her assumptions about Kanye West were influenced by his public controversies and media persona. Yes, West was extraordinarily successful in music. Yes, he had built a fashion empire, but in Jackson's view, he was simply another celebrity using legal theatrics rather than a genuine advocate for artistic rights. This assessment would prove to be a fundamental miscalculation. Kanye's hidden journey. From beats to constitutional law. The world knew Kanye West through his musical evolution and cultural impact. From producing for Jay-Z to becoming a Grammy-winning solo artist, from launching Yeezy to reshaping fashion, his creative influence had extended far beyond music. With a career spanning over 2 decades and billions in revenue, West had become one of the most powerful figures in entertainment. But what the public didn't know was that Kanye's business success had sparked an intense intellectual curiosity about the legal frameworks governing creative expression and intellectual property. Starting in 2008, frustrated by various legal disputes over his music and fashion designs, Kanye had begun intensive study of copyright law and constitutional creative rights. The system tries to control artists through contracts and copyright, he had confided to his longtime collaborator Mike Dean during a late-night studio session. "If I'm going to protect my creative vision and help other artists, I need to understand the legal system that governs our work." Working with intellectual property professors from Columbia and NYU, Kanye spent his time between projects studying Supreme Court copyright precedents, trademark law, and the constitutional foundations of creative protection. He completed advanced coursework in intellectual property law, constitutional interpretation, and the intersection of creativity with legal governance. By 2023, when the case that would bring him to federal court emerged, Kanye wasn't just defending his commercial interests, he was also a well-educated advocate for artistic rights, with genuine expertise in the constitutional law that governed creative expression and intellectual property. The Case Foundation. Creative expression versus corporate control. The federal case that brought Kanye West before Judge Jackson represented one of the most significant intellectual property challenges in entertainment history. West versus Universal Music Group challenged the record industry's standard contract practices as violations of both constitutional creative rights and federal antitrust law. The case had emerged when Kanye filed a comprehensive lawsuit claiming that major record labels used copyright assignments and exclusivity contracts to create an illegal monopoly over artistic expression. He argued that industry-standard contracts violated artists' constitutional rights to creative expression and operated as an unlawful restraint on artistic commerce. The implications extended far beyond Kanye's situation. If his legal theory prevailed, it would fundamentally reshape the entertainment industry and establish new constitutional protections for artistic expression. If the record labels won, it would confirm that copyright law could be used to control creative expression without constitutional constraint. For Jackson, this case represented an opportunity to clarify the relationship between intellectual property law and constitutional creative rights. She viewed it as a complex matter of balancing legitimate commercial interests with constitutional protections for expression. For Kanye, the case was about fundamental constitutional principles, whether artists retained constitutional rights to their creative expression even after signing commercial contracts, and whether the entertainment industry could use copyright law to suppress artistic freedom. The setting, New York Federal District Court. The imposing courtroom of the U.S. District Court for the Southern District of New York was packed with entertainment lawyers, intellectual property scholars, and music industry executives. This case had drawn international attention, both because of Kanye's celebrity status and its potential impact on artist rights and intellectual property law. At the plaintiff's table sat Kanye West, dressed in a sleek black suit that projected artistic seriousness rather than fashion statement. His legal team from top entertainment law firms flanked him, though Kanye had insisted on presenting key constitutional arguments himself, a decision that had surprised intellectual property law experts. At the defense table, Universal Music Group had assembled their most experienced intellectual property attorneys, led by General Counsel Maria Rodriguez, a Stanford law graduate with decades of experience in entertainment litigation. Behind them sat executives from major record labels and music publishing companies, all confident this would establish important precedents protecting industry business models. Judge Jackson, presiding over this case due to its constitutional significance for creative rights, had already expressed skepticism about celebrity constitutional claims through her previous entertainment law rulings. First contact, the dismissive challenge. Mr. West, Judge Jackson began, her voice carrying the authority of constitutional scholarship. This court recognizes your commercial success in the entertainment industry. However, intellectual property law involves complex constitutional principles and sophisticated legal frameworks. Are you prepared to engage seriously with established copyright doctrine rather than asserting constitutional objections to legitimate business practices? The question was designed to highlight what Jackson saw as the fundamental difference between artistic success and legal expertise. Her tone suggested she expected Kanye to rely on his legal team or demonstrate the kind of constitutional superficiality she associated with celebrity legal challenges. Kanye stood deliberately, his posture respectful but confident. Your Honor, I appreciate your concern about legal complexity. However, I'd like to address that concern by discussing the Supreme Court's analysis in Harper & Row Publishers v. Nation Enterprises and how copyright law must serve constitutional purposes rather than suppress creative expression. A surprised murmur went through the courtroom. This wasn't the celebrity legal theater Jackson had expected. The Copyright Clause, Kanye continued, grants Congress power to promote the progress of useful arts by securing exclusive rights to authors for limited times. But when copyright assignments permanently separate artists from their creative expression, they violate the constitutional purpose of promoting artistic progress. Jackson's expression shifted slightly. The response demonstrated actual understanding of constitutional copyright theory, not just entertainment industry talking points. Testing the constitutional waters, Mr. West, Jackson continued, her tone becoming more serious. Citing constitutional text is one thing. Understanding how modern courts balance copyright protection against First Amendment creative rights is quite another. Are you familiar with how contemporary intellectual property law addresses competing constitutional values? This was the kind of question designed to separate constitutional amateurs from serious intellectual property scholars. Kanye nodded confidently. Absolutely, Your Honor. The court's framework in Eldred v. Ashcroft establishes that copyright law receives constitutional deference when it serves the constitutional purpose of promoting creative expression. But when copyright practices suppress rather than promote artistic creation, they exceed constitutional bounds. Jackson leaned forward, her interest clearly piqued. Continue with your constitutional analysis. The entertainment industry's standard contracts, Kanye proceeded, violate this constitutional framework because they transfer not just commercial rights, but creative control itself. When artists lose the ability to build upon their own creative expression, copyright law becomes a tool for suppressing rather than promoting artistic progress. The courtroom had grown quiet. Entertainment reporters were taking detailed notes, and even Universal's attorneys were paying close attention to this unexpected constitutional discourse. The revelation: Kanye's intellectual property expertise. Mr. West, Jackson said, her tone now markedly different from her initial dismissiveness, your constitutional analysis of intellectual property demonstrates considerable legal sophistication. Where did you develop this expertise in copyright law and constitutional creative rights? Kanye's response would reveal the depth of his legal preparation. Your Honor, I've spent over 15 years studying intellectual property law and constitutional creative rights, initially through Columbia Law's executive program in entertainment and media law, later through private study with constitutional scholars specializing in artistic expression and copyright theory. I've worked directly with Professor Jane Ginsburg at Columbia on copyright constitutional theory, studied under Professor Rebecca Tushnet at Harvard on trademark and creative expression, and completed advanced coursework through New York University's Creative Rights program, focusing specifically on the intersection of artistic expression, intellectual property, and constitutional law. The courtroom buzzed with surprise. Jackson herself looked genuinely taken aback. Moreover, Kanye continued, my practical experience as an artist and entrepreneur has given me unique insight into how intellectual property law affects creative expression. I've seen firsthand how copyright practices can either promote or suppress artistic innovation. Escalation point, 8 to 12 minutes, Jackson's deeper constitutional challenge. Jackson, now taking Kanye's argument seriously, decided to test the deepest level of his constitutional understanding. Mr. West, your case essentially argues that standard entertainment contracts violate constitutional creative rights. But how do you address the legitimate commercial interests that copyright law was designed to protect? This question went to the heart of modern intellectual property law, the sophisticated balance between commercial incentives and creative freedom that typically separated legal generalists from serious copyright scholars. Kanye's answer would demonstrate whether he truly understood the complexities of constitutional law in the creative context. Your Honor, there's a crucial distinction between protecting commercial incentives for creation, which the Constitution supports, and transferring creative control in ways that suppress future artistic expression, which violates constitutional purposes. He paused to organize his constitutional argument. The Supreme Court's decision in Campbell v. Acuff Rose Music recognized that copyright law must accommodate transformative creative expression, even when it builds upon existing works. This principle applies even more strongly to artists building upon their own creative expression. Jackson was now fully engaged with Kanye's constitutional analysis. You're arguing that artists retain constitutional rights to build upon their own creative work. I'm arguing that when copyright transfers prevent artists from engaging with their own creative expression, they violate both the Copyright Clause's purpose and First Amendment protections for artistic expression, Kanye responded. The Constitution protects the right to create, and this includes the right to build upon one's own creative foundations. Precedent analysis, building creative constitutional framework. Moreover, Kanye continued, we have direct precedent for protecting creative expression from contractual suppression. The The Supreme Court's decision in Brown v. Entertainment Merchants Association recognized that creative expression, including music, fashion, and visual art, receives First Amendment protection regardless of its commercial context. Jackson was taking careful notes. How does Brown apply to your contract challenge? Brown's constitutional principle applies directly to standard entertainment contracts, Kanye replied. When record labels use copyright assignments to control not just commercial distribution, but creative direction itself, they're restricting protected expression based on content and viewpoint. Kanye then presented his most sophisticated constitutional argument. The court's recent decision in Iancu v. Brunetti confirms that government cannot suppress creative expression simply because it challenges established commercial or cultural norms. When applied to copyright law, this means that intellectual property practices cannot suppress artistic expression merely to maintain industry business models. Jackson's constitutional recognition. The change in Judge Jackson was evident to everyone in the courtroom. Her initial skepticism had evolved into genuine engagement with Kanye's constitutional arguments. "Mr. West," Jackson said, "I must acknowledge that your constitutional analysis has been exceptionally sophisticated. You've presented arguments about creative rights and intellectual property that merit serious consideration from this court." "Thank you, Your Honor," Kanye responded. "I hope this demonstrates that constitutional creative rights belong to all artists, not just those with traditional legal credentials. The First Amendment and Copyright Clause work together to protect artistic expression, and this protection must be real rather than theoretical." Jackson nodded thoughtfully. "Your argument essentially contends that intellectual property law must serve constitutional creative purposes rather than simply protecting commercial arrangements. This raises fundamental questions about the relationship between copyright and constitutional rights." The industry's constitutional defense general counsel Rodriguez, representing Universal, attempted to refocus the constitutional conversation. "Your Honor, while Mr. West's constitutional studies are noteworthy, the fundamental issue remains commercial certainty. The entertainment industry depends on stable copyright assignments to fund artistic creation." Jackson turned to Rodriguez with new interest in the constitutional balance. "Counselor, how does the industry respond to Mr. West's argument that copyright assignments can violate constitutional creative rights when they suppress artistic expression?" Rodriguez found herself defending industry practices against sophisticated constitutional arguments rather than dismissing celebrity legal challenges. "Your Honor, artists voluntarily enter into these contracts and receive substantial commercial benefits in exchange for copyright transfers." Kanye was prepared for this constitutional response. "Your Honor, the industry's voluntary contract argument ignores the constitutional principle that fundamental rights cannot be waived through commercial agreements when doing so undermines constitutional purposes. In unconstitutional conditions doctrine, this court has consistently held that government benefits cannot be conditioned on surrendering constitutional rights. Constitutional framework development. Kanye then presented his proposed constitutional solution. "I suggest a framework that protects both commercial incentives and constitutional creative rights. First, copyright assignments can transfer commercial rights without transferring creative control. Second, artists must retain constitutional rights to build upon their own creative expression. Third, industry practices must serve constitutional purposes of promoting artistic progress rather than merely protecting established commercial models." Jackson engaged directly with this constitutional framework. "How would your framework address industry concerns about commercial certainty and investment protection?" "The framework protects legitimate commercial interests while ensuring they serve constitutional purposes," Kanye responded. "Rather than suppressing creative expression, the industry can develop business models that promote rather than restrict artistic innovation. The Constitution requires this approach because intellectual property exists to serve creativity, not to control it." Kanye concluded with his strongest constitutional argument. The Copyright Clause and First Amendment work together to protect creative expression as both a commercial and constitutional right. When the entertainment industry uses copyright law to suppress rather than promote artistic expression, it violates the constitutional foundations that make intellectual property legitimate. Jackson's final constitutional assessment. As the hearing concluded, Judge Jackson addressed Kanye directly. "Mr. West, your constitutional arguments today have been remarkable. You've demonstrated understanding of intellectual property law and creative rights that rivals the most experienced constitutional advocates in this field." "Thank you, Your Honor. This case has never been about attacking copyright law or avoiding commercial obligations. It's been about ensuring that intellectual property serves its constitutional purpose of promoting creative expression rather than suppressing it." Jackson reflected on the broader constitutional issues. "Your arguments raise fundamental questions about the relationship between commercial arrangements and constitutional creative rights. This court will examine them with the constitutional rigor they deserve." The landmark creative rights decision. 3 weeks later, Judge Jackson issued a comprehensive 44-page decision that would revolutionize entertainment law and artistic constitutional rights. The ruling found that industry-standard copyright assignments violated constitutional creative rights when they prevented artists from building upon their own creative expression. More significantly, Jackson's opinion adopted key elements of Kanye's constitutional framework, creating new precedent for how courts would evaluate intellectual property practices against constitutional creative protections. The decision included an extraordinary judicial acknowledgement. This case demonstrates that constitutional wisdom about creative rights often emerges from those who live the practical effects of intellectual property law. Mr. West's analysis has contributed meaningfully to this court's understanding of constitutional protections for artistic expression. Broader constitutional and industry impact. The West v. East Universal decision created immediate changes in entertainment industry practices and sparked national conversation about artist rights and intellectual property law. Constitutional law scholars praised the decision as a landmark victory for creative constitutional rights. Law schools immediately began incorporating Kanye's constitutional arguments into their intellectual property and constitutional law curricula. The case became required reading for entertainment law, constitutional law, and creative rights courses nationwide. For the entertainment industry, the decision established crucial precedents protecting artistic expression while requiring industry practices to serve constitutional purposes rather than merely commercial control. Long-term constitutional legacy. The constitutional precedents established in West v. Universal influenced creative rights law for years afterward. The decision's framework for protecting artistic expression from commercial suppression became a model for courts addressing creativity in constitutional law. Most importantly, the case demonstrated that constitutional expertise could emerge from creative experience, and that the most meaningful artistic rights arguments often came from those who understood both creative expression and constitutional principles. Kanye West had proven that true constitutional advocacy for creative rights requires combining artistic understanding with rigorous legal scholarship, and that protecting creative expression demands the same constitutional courage that has always been necessary to defend fundamental freedoms. If you found this incredible fictional story of creative constitutional courage and hidden legal brilliance inspiring, please hit that like button and subscribe to our channel for more amazing tales of unexpected expertise challenging established authority. Ring that notification bell so you never miss these extraordinary fictional stories of how constitutional knowledge and creative innovation can combine to protect fundamental rights. What did you think of this fictional portrayal of Kanye's constitutional expertise? Share your thoughts in the comments below. Important note, this is a completely fictional story created for entertainment purposes. Any resemblance to real events or persons is purely coincidental.